Hey class, welcome to part 2 for week 12. In this part, we are going to talk about state open records laws, so the state equivalent of FOIA, as well as the Privacy Act, that's federal law, and the Federal Government in the Sunshine Act. So in general, state open records laws pretty much mirror FOIA. They've got this presumption of openness, but they also have exceptions or exemptions to disclosure. And while they generally look like FOIA, there are some variations between the states. So some states have additional mandatory non-disclosures where an agency simply cannot release information, whereas other states might not. Now, one thing to note is that for state governments, complying with Open Records Acts, or Public Information Acts, Freedom of Information Acts, whatever you want to call them, it can be very expensive. It can be expensive for the feds as well, but the feds have FOIA offices, supposedly, with dedicated staff. At the state level, a lot of agencies do not have specific FOIA offices, and so when they go to respond to a public records request, they effectively have to stop the other work that they are doing in order to go search for, collect, and review records. At the University of Maryland, we have the Public Information Act, the PIA. For reasons that I really do not understand, our PIA requests have absolutely exploded over the past 2 years. We now get several of them per day. And my office, the Office of General Counsel, is the unit responsible for responding to PIA requests. But because we don't have anyone dedicated to it, all of the attorneys have to pitch in. So I, for instance, handle the requests that relate to our research, but I'm also the primary attorney that supports the campus's entire, $600 billion plus research enterprise. So if I get a huge open records request and it just takes me a lot of time to deal with it, and I've got to bring in numerous other offices to gather records, it does get very expensive, and it's not just a monetary issue, it's that you're losing time to work on other projects. Now, it is possible for states to get funding. They can charge for these open records requests. It really depends on the state, though. Typically, you've got to give at least the first 2 hours free of charge, and then there are sometimes state statutes are structured much like FOIA, where if you're a commercial requester, you're going to pay full freight. If you're not, there's going to be a reduced cost or no cost. The Colorado Open Records Act, or CORA, it requires most public records, including emails, be available to the public. And it requires that agencies make a proactive attempt to disclose information even without a CORA request. So it's possible that if you want specific information from a Colorado agency, you got to submit a CORA request. However, you might be able to just look through basically their equivalent of the FOIA reading room. Now, CORA is especially challenging for Colorado agencies because it gives them 3 working days to comply with a request. And honestly, 3 working days isn't enough time to even determine whether you're permitted to disclose certain types of information. So to collect all the records, review and redact them, get in touch with any private parties whose information might be included, and give them a chance to request non-disclosure of confidential information, all of that, it's really possible to do within 3 days. Now, Colorado does have exemptions to disclosure. That includes privileged information, attorney-client privileged stuff, as well as pre-decisional information. And that can be things like memos that are written to provide decision makers with information, but not to make a decision itself. That final decision, that final memo is going to be available. But those pre-decisional memos are not, because we want agency employees to feel like they can have open, honest discussions with each other, while in the process of providing information to the decision makers. So for instance, if your policy and analysis memo, if you wrote that for your actual job, it would be exempt from disclosure because it is pre-decisional. You are analyzing various options and you're making recommendations, but you are not making the final decision. CORA also exempts certain law enforcement records, all of the personally identifiable information, and then things like test questions and scoring keys, which would be important for instance, the bar exam or your medical boards. And obviously those are exempt because we don't want people to be able to get a hold of them and game the system. So as I mentioned, Maryland's got the PIA, and while it provides 10 days to respond rather than Colorado's 3 working days, the Maryland law counts calendar days, and it does not affirmatively state that a request made after the close of business is going to be deemed received on the next business day. And so this allows requesters to get kind of tricky. You know, they'll submit at 8 p.m. on a Friday on a holiday weekend, and that clock starts running, but we, the people responsible for responding, effectively lose, 2, 3, or even more days. Additionally, the Maryland law does not provide any protection from abusive requests. And so one year, not too long ago, we actually had a single person submit almost 150 open records requests. And his point was to simply disrupt the university's operations, not to obtain information in good faith. Okay, moving on from these open records laws, let's take a look at the Privacy Act. So like FOIA, the Privacy Act is part of the Administrative Procedures Act. There are other federal statutes, of course, that impose privacy requirements. Health Insurance Portability and Accountability Act, or HIPAA, the Federal Education Rights and Privacy Act, FERPA, a number of different statutes have privacy requirements, but the Privacy Act itself sort of operates as a catch-all. The Privacy Act withholds sensitive documents from public disclosure, and it is protecting the privacy of records that are compiled about individuals. And records can be, any type of item or collection or grouping of information that an agency is maintaining about an individual. So a lot of times, that's employment, education, financial transactions, criminal history, etc. So as we have discussed, agencies are allowed to collect information about people. They are, however, limited to maintaining a system of records that they need in order to accomplish their purpose. So, whatever Congress tells them in a statute or the president tells them in an executive order. It is also important to note that businesses are not considered individuals under the Privacy Act. So corporations are legal persons, but they are not individuals. And so they are not entitled to Privacy Act protections. They are for individual human beings only. So some examples of the information that agencies collect that would be protected by the Privacy Act, things like tax documents. They include your name, your address, your phone number, your marital status, your home ownership status, your investments if you're fortunate enough to have them, your medical expenses. Your tax records just have a ton of information about you. Same for any type of benefit program. You're getting veterans benefits or Social Security or Medicare and Medicaid. They collect a lot of information, including things like, do you smoke cigarettes? If you attend a public university, the state government's got your high school transcripts, your SAT scores, and the like. When agencies are entitled to collect all of this information, they are supposed to collect it directly from us, the individuals, whenever possible. And in that request for information, the agency has to tell us, the individual, what their authority is to obtain the information, whether the disclosure is voluntary or involuntary. You have to file your taxes, why the agency needs the information, how the agency is going to use the information, and then any consequences to you for not handing over that information. And to ensure fairness to us as individuals, agencies have to monitor their records to ensure that the information they're keeping is accurate, relevant, complete, and updated in a timely manner. Also important to know that agencies cannot maintain records of how an individual exercises their First Amendment rights. So that includes even information about books that you might check out from the public library, if in fact people still do that. Agencies also have to make reasonable efforts to notify individuals when they're going to disclose information about that individual. And typically that would be disclosed pursuant to some type of compulsory legal process like a subpoena. And agencies have to establish rules of conduct for employees who handle records And they also have to establish safeguards to protect against security threats. You don't want your system hacked and a whole bunch of personal information getting out there. So agencies do impose physical, technical, and administrative safeguards in order to maintain records about individuals. And the Privacy Act prohibits disclosing any record about an individual unless the agency obtains that individual's consent, or the record falls into a Privacy Act exemption. Now, again, keep in mind, the Privacy Act does not apply to a huge number of records that the government keeps, because many records are not about individuals. They are about companies or other organizations. And there are exemptions to the Privacy Act. As with most laws that relate to privacy, individual consent is a major exemption. So if you consent to the disclosure of your personal information, then the agency can disclose it. The other exemptions are mostly common sense. The Privacy Act does not protect your information if it's relevant to law enforcement investigation, or if it's subpoenaed by a court, or if the information is needed to protect the health and safety of the individual or members of the public, etc. The Privacy Act does require that agencies keep a record anytime they disclose information about an individual. They've got to include the date of disclosure, the general nature of the request for the information, the purpose of the disclosure, and then contact information for the party to whom the information was disclosed. And agencies have to keep these records for 5 years, or the life of the record, whichever is longer. In practice, FOIA almost always applies to requests for information. Those requests are typically for government reports and other government data. The Privacy Act applies in far fewer cases because, again, it is about an individual human being. When information that is requested constitutes a record, both FOIA and the Privacy Act apply. And how do they work together? In practice, the Privacy Act converts FOIA's discretionary disclosures into mandatory non-disclosures. So you could just pause here and take a look at the various interactions between FOIA and the Privacy Act that I've got shown on the screen. And here is the federal government's comparison of the two statutes. And so you can see that FOIA protects the public's right to know what the government is doing, and the Privacy Act protects the individual's right to keep our private information private, or as private as possible. In addition, individuals have a right to access their records. So you can go to the FBI and ask for your FBI record if they happen to be keeping one on you. You can bring an attorney, a family member, or somebody else with you to review those records. And you can ask the agency to correct any information that they've got in an agency record that is inaccurate. And if you make that request, the agency's got 10 days to correct it, or they have to notify you why they are not going to correct it. And an agency decision not to correct a record, you can appeal that to the agency head, who then has to issue a prompt decision. And like FOIA, the Privacy Act provides for judicial review. That is available when the agency head, decides, yep, you're not going to correct the information in the record, or if an agency refuses access to your own records, or if you are somehow harmed because an agency fails to maintain records with required accuracy or relevance or completeness. So to get that judicial review, you've got to file a claim against the government in one of those 4 federal district courts referenced in FOIA, and you've got to file within 2 years of the date on which you discovered the problem with your record, or a reasonable person would have discovered a problem with the record. And similar to FOIA, judicial review is de novo, so from scratch. In-camera review is permitted, so the judge can take the documents, the records, back to her chambers and review them privately, and the burden of proof is on the agency. If you, the individual, win at court against the agency, and these are civil claims, that you're bringing as an individual, The court can order the agency to correct your record, order the agency to disclose your record to you if they had been refusing to do so, or order the agency not to disclose the records to anyone other than you. There are also 2 penalties that are criminal that apply to government personnel who violate the Privacy Act. They're both misdemeanors, but they carry a fine of up to $5,000. And those penalties attach if a government employee discloses a record that they knew should have been withheld, or if they willfully maintain a record without satisfying the notice requirements. So they're not telling you about it, they're not explaining their authority to do so. The Privacy Act also imposes a penalty on individuals who knowingly and willfully request or obtain a record under false pretenses. That is also a misdemeanor, but again, $5,000 fine. Like FOIA, the Privacy Act requires reporting to Congress. The requirements are a little bit different. Each agency's got to give notice to Congress as well as to the Office of Management and Budget about any proposed changes that they are making to their system of records. Additionally, the president has to submit an annual report on Privacy Act, which disclosures were made, under what exemptions, etc. So FOIA and the Privacy Act are about records, and the government in the Sunshine Act is about meetings. So the Sunshine Act, also part of the APA, it is based on Madison's Federalist Paper number 49, method of guarding against the encroachments of any one department of government. And the Sunshine Act applies to agency meetings if the agency is headed by more than one person. So keep in mind the term agency, that also means boards and commissions. And the Act requires that those agencies give 1 week advance notice of any meetings and allow the public to attend those meetings. So what's a meeting? The Sunshine Act defines a meeting as the deliberations of at least the number of individual agency members required to take action on behalf of the agency, where such deliberations determine or result in the joint conduct or disposition of official agency business. Great definition. What the heck does that mean? It means there got to be enough attendees at the meeting to fulfill any quorum requirements so that your vote can be binding, and the meeting's got to involve some type of deliberation of agency business. So any type of formal agency action definitely fits into these categories, as do meetings that involve significant discussions about agency business. Informal meetings, though, informal discussions, and that can include meetings to discuss differing views within the agency, they are not covered by the Sunshine Act. They do not have to be open. Naturally, there are exemptions to the Sunshine Act, and they will sound familiar to you. So they include meetings that touch upon matters of national defense or foreign policy, stuff that's just about the internal agency rules and practices, information exempted by other statutes, etc. So the Sunshine Act also provides for judicial review. To get review, you've got to file your claim against the government in the district where the agency meeting is held, or where the agency is headquartered, or catch-all District of Columbia. And when I say in the district, I mean the district court for the district of, whatever the geographical location is. You also have to file that claim within 60 days of the meeting. Much again like FOIA and the Privacy Act, judicial review is done de novo, in-camera review is permitted, and the burden of proof is on the agency to justify holding closed meetings. The court can order a number of remedies. It can do injunctive relief so the agency can't do this again in the future. It can order the agency to provide a transcript of the closed meeting, and it can award attorney's fees and court costs to the individual who brought the claim. Like FOIA, the Sunshine Act has a presumption of openness. Meetings can only be closed if an exemption applies. Under the Sunshine Act, agencies do not have to close meetings if an exemption applies. These are, for the most part, permissive exemptions, not mandatory ones. Other statutes can also override an exemption and require that a meeting that could be closed remain open. If an agency does close a meeting, it has to certify its reason for doing so, and it also has to keep a complete audio record and then a transcript of that closed meeting. And again, agencies have to submit an annual report to Congress. They've got to report their number of closed meetings, the reason why they closed them, and any litigation related to those closed meetings. Now, private parties that perform government functions, so federal contractors, or receive government funding, like grantees, or otherwise act under the authority of the government, they may also be subject to openness requirements even though they are private organizations. If a private organization performs a government function, or its services are directly supervised by the government, then openness requirements are supposed to apply. And that is because we don't want the government to be able to get around this by telling their contractors to do it. So when it comes to private organizations that are receiving government funding or acting for the government, courts are going to consider, the extent to which the government manages the daily operations or regulates the organizations, the extent to which the government funds that particular organization, how much authority the government has delegated to the organization, etc. And so, this is really something that kind of ties back to our discussion of government military contractors, because you don't necessarily hear about them getting open records requests, but technically they can. All right, that is it for this week. My apologies that part 2 here took a while to render so that I could post it. We do have a FOIA discussion. It is a scavenger hunt, so you're going to find some records that the FBI has released under FOIA and share your thoughts. And then, of course, your second memo on the Stafford Act is due. Remember, that collaborative discussion board is available, so please, if you've got questions about the memo or you just want to bounce ideas around, make use of that collaborative discussion board. All right, thank you. Have a good week. I'll see you on the discussion boards.